except rolling stock of urban road transport. Urban road transport means the bus facility that is available, the transportation that is available, the metro rail that is available, the MMTS that is available, or public transport that is available, that should be made accessible. Are you able to follow, please? This is what is called transport. The next one is energy. There is electricity generation, then uh, electricity transmission, electricity uh, distribution, oil pipelines, etc. Nowadays, in most of the places, especially on the outskirts, like Kukatpalli and all developed places, Nalagandla and all, you've got underground oil facility. There's ONGC has provided for underground gas supply, and oil also is supplied by pipelines. Then next one is electricity distribution. Then the infrastructure means the particular project also is given electricity, and electricity transmission also is given, and electricity generation also is given. That means all the facilities that a business requires has been provided. They are concisely called infrastructure. The next one is water. Please remember, water plays a very important part, sir, not only for domestic use, but also for conducting the business, and running the project, running the industry, running the factory, or running the particular establishment. So, for that purpose, proper facility has to be given for supply of water. That is the reason, sir, when we want foreign investments, when we want the FDI, what is called foreign direct investment, the persons who are going to have their factories, or the persons who are going to have their industries, or the persons who are going to set up employment growth, are the persons who are going to provide employment, are the persons who are going to contribute to the commercial wealth of the state concerned. All these facilities have to be given. And please remember, first and foremost is water facility has to be given. That is why it is said water supply pipelines. Then next one is solid waste management, sanitation. What do you mean by solid waste? Please remember, most of the riverbeds today are polluted with the solid waste. Suppose you see Musi was constructed or provided by Nizam to provide water supply to the entire Twin Cities, and Tangband, especially which we call it as Vinayak Sagar or we call it as Hussain Sagar, was constructed by Nizam. That is, it extends up to 800 acres to provide water supply to the Secunderabad area. But are the lakes, are you've got the Durgam Cheru also, or you've got the Miralam tank, or so many tanks are there where these tanks were made only for the purpose of supplying water to the domestic use as well as for commercial use. And today, the most important dispute which is going on between Telangana and Andhra after bifurcation and under the State Reorganization Act, their main dispute is regarding the Krishna waters and Godavari waters. That is, there is how much share Telangana has to get, how much share Andhra has to get, and the other riparian states what they have to get. That is before the Krishna River Management Board. So the question is, these facilities, unless it is given, please remember, water plays a very important part. That is why it is said, whenever you are dealing with industrial products, the industrial effluents, you must provide a pollution, that is a sewage treatment tank plant. That is where you try to test the sewerage and leave the effluents outside. But please remember, are these effluents being let into a proper place? No, they go and join the river, or they go and join the tank bunds and pollute it. That is the reason the government is also coming back with a heavy hand, and they are providing, saying that whenever pollution industries are there, they shall not be anywhere near the city. They should be on the outskirts. And next one is water treatment plants. Please remember, when you are letting out the wastewater, you must have treatment plants. That is, whatever the water is let into that, the effluents get separated and the clear water only goes. That is, otherwise the effluents are disposed of according to the convenience of the industry. Then next one is irrigation, dams, channels, embankments, and then sewage collection, then treatment, and what is called disposal systems. Sewage, that is what is called sewage collection, treatment, and disposal system. That is, sewage collection is you must have a mechanism whereby the government provides an infrastructure whereby the sewage means your drainage water is let out, and the drainage water is properly treated, and then you have sewage collection. That is, whatever is the dirt that is left, that is collected and then disposed of accordingly, or the sewage is also properly treated and is properly disposed of. Then irrigation, dams, channels, embankments. Channels, that is what irrigation, dams, channels, embankments. To be frank, I think most of you know the Kaleshwaram, which has been constructed spending crores of rupees, but because of faulty designs, it has collapsed. The question is, you must try to see that you provide water also for irrigation purposes. The main thing is, the question is, water has to be provided for the person who tries to have an infrastructure project, and his entire industry or the business depends upon the water that is supplied. The next one is pipelines, storm water drainage system. Please remember, in most of the, of course, our city also lacks in it. Whenever there's a small rain, also the roads get blocked, choked. There's a traffic congestion. So for that, they must have they must provide stormwater drains where even if it rains, the water is collected there and then it goes to the proper channel. If you don't have stormwater drains, what will happen is the bitumen that is used for laying roads, the bitumen will get washed away and you will have potholes. Then next one is communication, telecommunication, fixed network, including optic fiber, cable network, which provides broadband internet. Please remember, now we are in the era of what is called internet, the IT, or what is called information technology, and those days are gone when what you call, we didn't have the optic fiber. Today, with a thin optic fiber, you can provide telecommunications, you can provide cable network, you can provide net, you can provide Wi-Fi, you can provide so many things. So facilities will have to be on. These facilities are called infrastructure. Then next one is telecommunications, telecom services. Telecommunications means the various networks which are present, including BSNL, Geo, Airtel, and V and all. Those facilities will have to be made available. This is what is called one of the infrastructure facilities. Then communication is very important. And then next one is social and commercial infrastructure. That means educational institutions, capital stock. So it should be accessible to all the educational institutions. And because please remember, you don't stay alone. Suppose you stay in the neighborhood near the factory, you require a school where you can join your children. So educational institutions also should be accessible. And then sports infrastructure, like provision for sports, stadia, and infrastructure for academics for training, research in sports, and sports related activities. So incentive also is to be given for sports. You must have academies, then you must have training facilities, then you must also have stadiums where you can have the sports infrastructure, and then you can also have academics and research in sports and sports related activities, so that the persons who are there can take part in various sports and establish themselves. And then hospitals, medical colleges, paramedical training institutes, and diagnostic centers. So please remember, nowadays we do not know how long we'll keep our good health. We require diagnostic services, we require medical services, we require hospitals, we require Medicare. All these things will have to be provided. Then tourism infrastructure, namely three-star or higher category classified hotels located outside. So, because please remember, when you are going to have a big project, foreigners come. You must try to see that the tourism infrastructure has to be provided. A three-star or five-star hotel should be in the neighborhood so that you can lodge them there and give them all facilities. And then it is also said common infrastructure for industrial parks and other parks with the industrial activity and its what is called, and as food parks, textile parks, special economic zones, tourism facilities, and agricultural markets. Please remember, nowadays we have Raitu Bazaar, then we have government-run bazaars, then we have super bazaars, then we have what is called industrial parks are constituted at various places, and they come directly under the API, the TS. Now it's TG, I think TGIIC, that is Telangana Infrastructure Corporation. Then you have industrial parks. Only industries are located there. All facilities are given. So these things are all what is called social infrastructure. That is what is called. Uh, they are called category of project infrastructure. Then next one is uh, then terminal markets. Then you have soil testing, cold storage. Then what is called affordable housing. Then explanation is the term carpet area. So all these facilities which are given under various heads like transport, water, telecommunications, then social and then communications rather, and what is called social and what is called commercial infrastructure for communications, water, energy, transport. They are all what is called infrastructure facilities. So, Section 20A has been introduced by the Amending Act of 2018 by providing a schedule providing what are the types of infrastructure or the facilities to run a business on profitable lines. Then it is also said the central government, because it comes direct, the infrastructure facilities comes directly under the central government. The central government at any time can amend any of the projects, add any of the projects, or remove any of the projects, but it can do so only by issuing a notification and then publishing it in the official gazette and to be placed before both the houses of parliament in one session within 30 days or in the next session, and then get it passed by the parliament, and then in that case it becomes a law. So here it is within, that is why it is said in section 20A, 20A, 20B, 20C. Then 20C says the state government, please underline the word, the state government may, by notification, constitute special courts to deal with all the infrastructure projects and matters relating to specific performance relating to infrastructure projects, and special court shall dispose of the matters within within a short span, that is within 1 year, and then subject to extension by extension, that is extension, reasonable extension can be given. That is what 20C says. It says the notwithstanding anything, the suit filed under the provisions of this act shall be disposed of within a period of 12 months from the date of service of summons to the defendant, and may be extended for a further period not exceeding 6 months. So, in other words, all these special type of suits relating to infrastructure, the state government may constitute special courts to deal with the matter, and all suits of specific performance relating to infrastructure has to be disposed of within 12 months. And of course, there's a proviso also which says it can be extended for a maximum period of 6 months and not later. That is, the trial shall be speeded up. And in this regard, we have got an enactment called the Commercial Courts Act, which has been constituted, where the value is more than 1 crore. The commercial courts grant very rarely adjournments, because the specific performance suits will have to be disposed of within 12 months. And if it's not disposed of within 12 months, some not exceeding 6 months, it can be extended. But please bear one thing in mind, sir. The question is the as far as these infrastructure facilities are concerned, injunction cannot be granted, sir. Why? Because if injunction is granted, what would happen is the project which is sought to be constructed or established will be delayed. So these are the provisions as far as Section 20 vis-a-vis the amendments that have been brought about by the 2018 amendment. Then we go to 21. Power to award compensation in certain cases. That is, it is in a suit. In a suit for specific performance, the plaintiff may also claim compensation. If any such suit, the court decides for not to be granted, but it's a contract between the party which has been broken by the defendant, and the plaintiff is entitled for compensation, for that which should award him such compensation accordingly. Please remember, it doesn't mean that when you file a suit for specific performance, it should be automatically decreed. There are what is called various ways and means. Suppose, let us say, the court comes to the conclusion that the specific performance cannot be granted. In view of specific performance, the court grants what is called compensation by way of damages. And then uh, the plaintiff also, in a suit for specific performance, can claim compensation in addition to specific performance. Then, how the compensation is to be calculated, sir? It has to be calculated under the provisions of Section 73, which speaks about quantum merit, QUANTUM space merit, MERUIT. That means to the extent of the damage cost when it is evaluated, or in the opinion of the court, this is the probable amount, which is a probable damage cost to a person. Then that is called, the court determines the compensation accordingly as per the provisions of Section 7. Then we go to the next section, sir. That is Section 22. Power to grant relief for possession, partition, and refund of earnest money. Here, let us say, notwithstanding anything, the person suing for specific performance, the counsel is entitled to possession, partition, or any relief that may be granted. So, what is the use of getting specific performance, sir? If it is an occupation of the seller, I must be able to get possession. So in that case, I can also ask for possession under Section 22. So in addition to specific performance, I am also entitled to possession of the property. Suppose, let us say, the property has already been sold. Let us say in a suit for partition, one of the sharer sells his one-fourth share to an outsider. Let us say one-fourth share. Please remember that purchaser cannot say, sir, please now you take me as your brother. We'll all share together, and please give me one-fourth share. No. What he has to do is he must ask for partition and say, my vendor share, or the person was already a sharer, please carve out the share and give me possession of that property. Are you able to understand, please? Suppose A, B, C, and D are fighting in a partition suit. Let us say B is got one-fourth share in the property. B alienates his one-fourth share to one X. Then X can file a suit. X can claim what is called partition and say that my vendor share, that is B's share, one-fourth share, please divide it and allot that share to me because I purchased it. That is, the subsequent purchaser can ask for partition. He can also ask for partition and say, whatever my vendor is entitled, please give me that share with possession. Then next one is, it is also said that partition relief of you can also ask for possession in a suit for specific performance, and you can also ask for what is called refund of purchase money. So suppose the contract fails for any reason, then in that case, whatever monies are had and received are received by the seller who resigns from the contract, or the specific performance cannot be done, that money with interest has to be handed over to the opposite side, to the person who has filed the suit. But please remember, that's why I said, even if a child requires food, it has to cry to alert the mother. In the same way, when you have to have some relief, you must also claim it in your plaint. If you don't claim it, court is not bound to grant you. But the court can also give you time to amend your plaint and ask for this relief. Court can definitely grant what is called refund of earnest money. Then we go to liquidation of damages is barred to specific performance. What do you mean by liquidation of damages? Not a bar to see. Sometimes what happens is there are certain clauses which are inserted in terrorism. That is, both the parties are made known. Look, the contract between both of us is very, very sacred. None of us should violate the contract. None of us should commit a breach of contract. In case we commit a breach of contract, this is a sum which is liable to be paid by the person who has committed a wrong to the person who has been victimized. This is what is called liquidated damages. This is also dealt with by Section 74 of the Contract Act. It says a genuine pre-estimate of the loss or damage that is likely to be caused to a person as a result of any breach or violation committed by the erring party. That is what is called liquidated damages. Normally, suppose let us say there is a transaction of 50 lakhs, and let us say, in case either party does not fulfill the terms of the contract, they are liable to pay 5 lakhs towards liquidated damages. That means 5 lakhs is the genuine pre-estimate of the loss or damage that is likely to be caused to the person who has been victimized, or there is a breach of contract committed by a particular person and the other person is the sufferer. It's a genuine pre-estimate of the damage that is likely to be caused in case of breach or in case of violation. That is what is called liquidated damages. But please remember, Section 74 of the Contracts Act clearly says the court relieves against penalties, but definitely imposes liquidated damage. What do you mean by that? It means, suppose I agree to purchase a property for 50 lakhs, and suppose the vendor does not pay the money, that is 50 lakhs on the appointed day, then the vendor says the vendor becomes liable to pay double the amount. Please remember, we are not in Satta Bazari where we play dice and say we are going to get money, or Rummy where we try to make money. No, penalty means, suppose if the transaction is for 50 lakhs, I cannot say the purchaser has to pay 75 lakhs in order to get the property, because though it's a clause, it's not that liquidated damages, because it is much more than the actual amount fixed under the contract. So penalties are never imposed, never enforced. I'm sorry, not imposed, never enforced by courts, because where it is more than the amount that is contracted for, court relieves against penalty. But liquidated damages is if it is a genuine pre-estimate of the loss that is likely to be caused in case of breach or in case of violation, it can definitely be awarded in addition to specific purpose. That is what section 23 deals with. Sir. 24 is bar for compensation for breach after dismissal of a suit for, suppose let us say you file a suit for specific performance. Your suit for specific performance is dismissed. Then in that particular case, later on, you cannot file a suit for what is called damages. Why? Because the main crux of the matter itself is gone. The residue does not remain. Are you able to understand, please? Suppose your suit is what you file for specific performance is negated by the court, is held against you. You have lost the case. Then you, later on, you cannot file another suit and ask for damages. There ends the matter. Are you able to understand? This is what section 24 deals with. Then 25th, 25 is that is notwithstand, that is, it is why it's said in certain awards and testamentary directions to execute settlements. In the provisions of this chapter, is contract shall apply to awards to which arbitration act applies. Arbitration and conciliation apply does not apply, and to directions in a will or codicil to execute a particular settlement. Suppose later, what do you mean by will and a codicil? Sir? Will means the desire of the testator. Testator means the person who executes the will. Wasiyat, Virunama, as you call it. The desire or the intention of the testator is expressed in the will. He has got various properties. He settles it in favor of his legal heirs, be it his sons or daughters or his widow. I'm not widow, sorry, as a wife. Then he gives certain directions there. How this, or let us say, certain settlements have to be made, certain adjustments have to be made, certain liabilities have to be discharged, or certain loans have to be paid. All these things are written in the will. And how they are settled is section 20 or 25 says, if whatever applies in this act shall also apply to awards given by the arbitrators, and it shall also apply to the settlements in a will or a codicil to execute a particular settlement. Suppose, let us say, the testator has to pay certain loans to third parties. Then he can say, please, the legatees or the beneficiaries, please execute a settlement in favor of my creditors, discharge the debt before you get the property. So all these things can be done under the provisions of section 25. Then to this, you have got section 29. Section 29. Yes, sir. Section 29, alternative prayer for rescission in a suit for specific performance. Here, it is said a plaintiff instituting a suit for specific performance pray in the alternative for that if the contract cannot be specifically enforced, it may be rescinded and delivered up to be cancelled, and it refuses to enforce the contract specifically, may direct it to be rescinded and delivered up accordingly. So, in addition to specific performance, you can say in case specific performance cannot be awarded, cannot be given, then in that case, please give me the option of the alternative prayer to resign, to avoid, to retract, or to revoke from the contract and get away from it. That is what section 29 says. Section 30 says the court may require parties resigning to do equity. Please remember, in English there is a saying, you cannot have the cake and eat it too. Suppose you want to resign the contract, you want to avoid the contract, you want to retract from the contract, or you want to revoke the contract, whatever benefits are had and received by you has to be refunded to the opposite side, restored to the opposite side. That is why it is said restitution stops when repayment begins. So the question is, when you are avoiding, when you are resigning, when you are exercising the right of rescission, then in that case, whatever benefits you have had under that particular contract, which you are resigning, which you are avoiding, which you are retracting, which you are revoking, you'll have to restore it back to the opposite side. So this finishes the chapter on specific performance. Then, by the way, since we have got time, I will deal with the small topic. This is nothing but not to belittle anyone, not to humiliate anyone, not to degrade anyone, or not to show disrespect to anyone. All of you are responsible people. I will just give you some hints regarding some practical aspects of the profession. Here, when I in most of the seminars, this only by the way, sir. It's not any. It's not part of the lecture. In some of the seminars and workshops and conferences, when I met various judges, they say nowadays the juniors do not have the etiquette, how to address the court, how to behave in the court, how to respect the elders, how to respect the brother advocates, and how to keep quiet as far as the court is concerned. And they have to also follow the dress code, in what dress they are coming. Sir, I told them also, sir, they have to be educated. And the question is, we must first know there are two wings of the judiciary. One is called the bench and another is called the bar. And both must have equal respect for each other. Both of us should act with cordiality. There should not be any animus and there should not be any poison in the minds of both of us. And there should be a smooth conduct of the business of the court. And when you address the court, you have to address it with humility. But nowadays, we find most of the lady advocates address the court as my lord, my lord, my lord, and all. There is an High Court circular which says the lower court judges are not my lords or your honor. They are all colonial words that are used. Now, when it's a lady judge, use the word madam. When it's a gents who are the judges, you say sir. That is enough. You need not use the word my lord, my lord, my lord 100 times. I think perhaps you use that word because to impress the court that you are a high court advocate practicing in the high court. Please remember the lower courts are not my lord, including high court. When we say sir or madam, it is sufficient. You need not go to that extreme extent. Second and foremost is try to show this is I'm dealing with the professional ethics, please. As far as your brethren are concerned, belonging to your same faculty, fraternity, try to show respect for them. Try to show respect for their learning. If they are short in learning, don't try to mock at them. Don't try to ridicule them, or don't try to put them to shame, or try to behave in such a way that, after all of us are brothers and sisters belonging to the same noble profession called the legal profession. The third one is when you are the next ethics, which is important, or the etiquette which you have to follow is when you request for an adjournment from the court, don't say, sir, you can't say even sir, post it to 18.4, post it to 18.6. Please remember the gut, any judge, be it a lady or be it a male, they'll get irritated and say, are you ordering me? Are you commanding me? You see, after all, you have some humility by saying, sir, kindly post this matter to 18.6. It's more decent. Then the question is, when a witness is in the witness box for cross-examination, don't try to humiliate the witness. Don't try to insult the witness. Don't try to annoy the witness. Don't try to slander the witness. Don't try to use defamatory words as far as the witness is concerned. Please treat him with due respect. After all, he is also a human being like you and me. The question is, you have to show, because one thing is this, who knows tomorrow that witness himself, seeing your ability for cross-examination, may be your client, or the opposite side may also become your client in future cases. So, as far as possible, show courtesy to the witnesses, show courtesy to the judge, go show courtesy to your brethren in the profession, and dress yourself properly, come in proper dress, and also try to address the court in a more polite way, and try to be more polite to your brethren or your fraternity. And when the other side is cross-examining or arguing, please don't try to ridicule him when he is doing it. And when you please remember, all of us do not have the same IQ. All of us may not be that intelligent like Solomon the Great, but still, We have to respect the learning of your opponent, however foolish he may be. Because the question is, the law does not give you the right to ridicule or insult your brother advocate. These are all the, of course, the question is dressing, of course. Dressing, of course, we find if you see the bar council rules or the advocates' rules, the advocate should be dressed in proper attire. That is, he must have a white shirt. He must have, of course, now it's very difficult to maintain white pants. White pants, then bands, and then the coat, black coat is prescribed for advocates. And if possible, when you are appearing in the High Court, you require a gown also, and try to come in a decent way and don't come with Hawaii chappals or rubber chappals to the court. Then next one is, as far as ladies are concerned, please remember most of the lady advocates come as if they're coming for a fashion show or reality show. Avoid such dressing. Please remember, I still remember a retired district judge by name Uday Gauri Prabhakar. She also became a district judge and subsequently retired. On our notice board itself, it is put, please, ladies are cautioned not to come in jean pants and t-shirts. Come in proper attire, come in proper dress, follow the dress code, and don't try to belittle the ladies who are there as far as family codes. Please remember, these are all small things which you have to follow. There's nothing wrong in following the rules. And normal etiquette is try to, and don't, one more, don't discuss your case with the opposite side. Don't discuss about your failings or your defects in your case, or don't try to discuss about the strength of your case. Don't try to find out what the other side is to say, or don't try to find out what points you are going to argue, sir, so that I can prepare. Please remember, these are all things which you have to avoid. Please remember, no one will teach you the etiquette, no one will teach you the ethics, no one will teach you the behavior, no one will teach you how to conduct yourself before a court. Then these things we have to follow, and we will be successful advocates and be loved and loved by all other your other brothers and sisters as far as the fraternity is concerned. Please remember, this is a, of course, I should not say because belonging to the same profession, this is a profession where jealousy is very, very common. Please remember, I used to still remember my senior was my father used to say, if someone is taking your name and talking against you, itself means that you have achieved much more than what he has achieved. So the reason is, when we have so many advocates are there, why should we take out your name? So be happy about it, be proud about it, and be courteous to the other side. You don't lose anything, and be courteous to the court. But again, for a moment, I'm saying the courts also provoke us, but then don't get provoked, because tomorrow the judge, after all, you are only an instrument. The judge has got the pen and the dictation power. Only he or she can dictate, and sometimes out of vindictiveness, your case may go against you. And then another thing is, no doubt you try to respect your client who engages you, but don't try to overstretch yourself by putting your arm on his shoulder and then taking him, have tea with him, or have tiffin with him, or have smoke with him, or have a pan with him. These are all things which you have to avoid, so that you keep a client at arm's length, and so that he may show respect to you, and respect your learning, and respect you in all respects. Then you can be a successful advocate. You can reach the pinnacle of success in this profession. These are the small points which I would like to make, and which I was directed by some of the judges to enlighten the not only juniors but also the upcoming seniors also in the profession, so that we maintain the dignity. Please remember, the dignity is already gone as far as the profession is concerned. Because the question is, we are participating in everything: dharnas, boycott, abstain, so on and so forth. But please remember, if you see the bar council rules, an advocate cannot boycott the court. I think in Maharashtra, 15 advocates were suspended by the bar council for taking part in the boycott. So boycott is a thing which should avoid. But unfortunately, what happens is, when you are in the multitude, when you got when the association, when all of them are abstaining, you will be a unique person who doesn't abstain. So these are all things which you have to bear it in mind. So the next subject which I will be dealing with is Negotiable Instruments Act, which will deal with that tomorrow. And Negotiable Instrument Act also, I will not be going into all the sections, please. I will be dealing with only the sections which are important from a professional point of view. For example, Section 4, which defines a promissory note, bill of exchange, and check. Then we have got what is called the difference between a promissory note and a demand promissory note. Then again we go into what is called, what do you mean by chair? What do you mean by crossing and special crossing? And then the golden presumptions as far as the Negotiable Instruments Act is concerned, there is Section 118 of the NI Act. Then bouncing of checks, we go to Section 138. Then compensation, Section 139. Then after that, 140, 140, 141 is not that important. 142, what are the prerequisites of a pre-existing monetary liability? Then 143 deals with what is called condonation of delay in filing complaints. 144 deals with what is called grant of interim compensation. 145 is whenever an appeal is filed, 20% of the money check amount has to be deposited in order to get stay. Then after that, you have got filing of evidence affidavits before the court's concerned. All these provisions are there. Previously contained only till 142. Today we have got 147 or 148 sections as far as NI Act is concerned. Don't expect me to deal with the entire NI Act. I will be dealing only with the practical aspects which is useful to our profession. Now please remember, today we were delayed because of the rains, heavy rains in Hyderabad. Some of you are in Hyderabad also know that today the rain started from 4 o'clock and ended only at 7:15 or 7:20. That is the reason there was a delay in starting the classes. Please excuse us for that. Now the interaction period starts. Yes, questions please. Huh? Yes, Mr. Vasantrao.
Sir, there's a cancellation of instruments.
Yes.
The section that is the cancellation of instrument under section that one between the parties to action and their privies. What is the meaning of privies?
Privies means parties to the contract, parties to the document, parties to the transaction, parties to the agreement. That is called privy. And the other thing is privity. Privity means the contract between them. That is called privity.
Okay. The legal of the party may seek a cancellation of document.
Sir, no. It is only the party to the document who can seek cancellation, sir. A person who is not a party, he has to go by 34 and 35. That is ask for declaration. He cannot ask for cancellation, sir.
Good. Thanks.
Next, please. Next. Next question, please.
Yes, any more questions?
Mr. Venkat? Yes. Mr. Sam?
Yes, sir. Specifically, I don't have any question today, sir.
Thank you very much. I'm obliged. చెప్పండి వసంతరావు గారు.
The jointly one property was jointly purchased by two persons.
Right.
And they in an agreement of pay.
Right.
Their legal heirs filed the suit for performance of agreement.
Right.
In the suit, there is another agreement between the two parties who bought the property to distribute the property.
Right.
After getting the
Right.
Then in the suit, he may claim for partition of the property of getting the
right. The question is, as far as when two people purchase the property, they are co-owners. So, as far as the share consideration is concerned, if they have contributed equally to that, they get half share each. But if the shares they don't contribute equally, but the amount is mentioned, then there is a provision in the Transfer of Property Act called Section 45, which says if the amount contributed by them is not mentioned separately, then they are entitled to equal shares. That's what 45 says, the Transfer of Property.
In that
And
suit, also they are entitled to
half share
get
each.
the
Half share each.
partition.
Half share each.
They are entitled.
Definitely.
Can I seek the prayer also?
Exactly, sir. You'll have to say how you have got that half. Your father or someone who has got that half share, and if you are two brothers, one fourth comes to you.
Okay, so that is what the judge is saying that there is another agreement between you and that is the earlier agreement
There,
between
the
us.
privity of contract doesn't apply, sir, because the man was purchased. This is dead and gone. Let us assume that. Then his legal heirs succeed to his property. That is to the extent of his half share. Then that half share has to be distributed among his legal heirs. That is his two sons. Let us put it that way.
Thanks.
Sir, regarding the follow-up question on the same topic, sir, can you brief me of the ouster, sir? Because in partition suit, something called ouster. So
Ouster,
can you
yes, sir.
enlighten
Ouster.
Yes,
Sir, here in
Ouster.
partition suit, suppose let us say the question is suppose the share is purchased by one of the legal heirs. Let us put it this way: by one B, who is one of the legal heirs of one X. Then when he purchases the share of his own brother, then the question is the other brother is ousted from asking for partition, or himself or his legal heirs. That's what is called ouster. Yes.
So is there any limitation, sir? I mean, that
For partition there is no limitation, sir. Sorry.
can be.
Yeah.
Okay.
Any more questions? Anybody? So take the lead and close the class.
Good evening, everyone. Any more questions today for today? Please go ahead if you have. Otherwise, we'll conclude the class. And sorry for the delay, we were stuck in the draft. So make sure that we start the question class as early as possible. Thank you. See you again tomorrow.
వాళ్ళు ఏమైంది తెలుసా 72 లిస్ట్